post-conviction review from prior administrations, and that's a nice segue into our panel, which is going to be on the dual roles the prosecutors have as ministers of justice and also as litigators in our adversary criminal justice system, the role of social justice in the adversary criminal justice system, and the problem of wrongful convictions and what prosecutors can and should do about it. And if there's time, there'll be some related discussion on mass incarceration. The burning question that I had last time was, whose security detail was it of the people on the panel? My guess is it was D.A. Jenkins. One, yeah. Not everybody gets security detail, right? Okay, so I'm going to announce our distinguished panel, and then I will let me tell you what the format's going to be. We have 5 questions, but it might be 4 questions. We might not get to question 5. So we have 4 questions amongst ourselves. Oh, you can't hear me. Okay, thank you. We have 4 questions, or 5 maybe, that we've discussed among ourselves. And I'm going to ask the question, and I'm going to call on the panelists in a particular order in each question. And I'm going to try to keep this to 10 questions, and it's okay for the panelists, they all know, to, if they have nothing to add to the prior answer, to say that. And I'm going to try to leave more time than we had in the last panel for audience questions. Okay, so let me do the distinguished introductions real quick, and then we'll get to the questions. Professor Laurie Levenson comes to us from Loyola Law School. She is the William Raines Fellow and the David Burcham Chair in Ethical Advocacy at Loyola Law School. I could spend 10 minutes introducing Professor Levenson. It is a great pleasure to have her here. She is one of the foremost voices in academia through her publications, her extensive media work in the study of prosecutors. She was a prosecutor for many years at the Central District of California, a federal prosecutor rising to the position of assistant division chief. And you've all read articles in which she's been quoted, and she runs the Exoneration Project, or is it the Innocence Project at Loyola Law School. We are very fortunate to have her here. Jeff Rosen is the Distinguished District Attorney of Santa Clara County since 2001. Jeff has been at the forefront of so much for so many years. I recently learned that we went to law school together and even took some classes together. I didn't realize that. He is a nationally recognized leader in criminal justice reform. He created, I think he was one of the first, if not the first, to create a conviction integrity unit in Santa Clara County. He has won awards. He's won awards for his work, including an award from the Northern California Innocence Project, which at the time, and probably still today, is staffed almost entirely by former defense attorneys, with one important exception. He's been innovative in a number of ways, from cold case units to family justice centers, to helping revise criminal laws in Santa Clara County and the state of California. It's a rare pleasure to also have Jeff Rosen on this panel. And Cassandra Jenecke is one of my former students, one of my former STAR students. She graduated from USF in 2013. I can't tell you how proud I am to have her here. She is the district attorney of Tuolumne County, not that far from here. Since 2021, she's been the district attorney. She's been in the office since 2015. She is a young, innovative, candid thinker on criminal justice reform and on prosecution. I was always struck in my wrongful conviction seminar, my criminal procedure class, how all of Cassandra's friends were all the students who wanted to become criminal defense attorneys and public defenders, and I suspect many of them still are. She is a star in the making, and if I were governor of California, I would make her my attorney general. Please give a round of applause to our panel. Okay, so the questions I'm going to ask are a little compound. So I apologize for that in advance. We're going to start with Professor Levenson, and then go to Cassandra, Jenecke, and Jeff Rosen. Unlike all other lawyers in our formally adversarial legal system, prosecutors have a dual duty to represent their client, the people represented by the state of California or the government, as zealously as possible, and to be ministers of justice. Can you give an example of how it is possible for these dual roles to conflict with each other in the trial or in the plea bargaining context, and how you resolved, or how you suggest that conflict should be resolved? I know you had a lot of experience as a prosecutor, but maybe think about these things in a broader way now.
Professor, I could give an example, but I'm not going to start with that. I'm actually going to start with thank yous, because really, frankly, folks, I am so honored to be here. That it was an amazing panel, the first panel, and this group I have such enormous respect for. But I didn't get here magically. I got here because you have people in your community who are really dedicated to criminal justice. Of course, I thank the dean for allowing us all to be here. But you should know that Laura Bazelon, Professor Bazelon, who put this all together, she put me together. She was the first director of Loyola's Project for the Innocent, because she has the heart of gold and the brain of a master. And came on in and said, let's take a look at what we can change in the criminal justice system. And in doing so, let's look at that role of prosecutors. But there are far more people who are here that I want to thank, including Professor Leo, who's done amazing work, Jeff Rosen, who I've known through the years, who's tried to be innovative, and back there working Linda Starr and her group from the Northern California Innocence Project. Because before I answer my question, you need to know just a little bit about my journey. Yes, I am a nerdy law professor, proud of it. But before becoming one, I was a federal prosecutor, and I was a real prosecutor. And I got to the law school, and I realized my students were asking me, gee, should I be a prosecutor or a defense lawyer? And my answer was both. And realizing that I wanted to be both. And that prosecutors actually should see their role in both ways. And so it was a little odd when this prosecutor started an Innocence Project at the law school. So that's by way of background, where I thank those people, and I see former members of our project here as well, for making me realize that the way I had learned about being a prosecutor in law school, where you are now, is just not the best way to learn about it. What is the role of a prosecutor? This is not on a quiz, but there are actually standards that talk about the role of a prosecutor. And they don't say, surprisingly, put everyone in prison or prosecute everyone. What they do say is that the prosecutor is not merely a case processor, but a problem solver, responsible for considering broad goals of the criminal justice system. It even says that a prosecutor should seek to reform and improve the system. And here's one as a quiz, because you got to call on people if you're a professor. Who out there knows who the client of the prosecutor is? Don't make me call on you. Mr. Wagstaff?
You're calling on me?
I'm calling on you. Hey, everybody. The client of the prosecutor is the public. Everybody out there. Not a particular government agency, not a police department, not even a witness. And although the victims are terribly important, they're not the only client. So now, Professor, to answer your question. Do I think that prosecutors are often put in a dual role in what we call the adversarial system? The answer is yes. Because the very definition of a prosecutor is, quote, a minister of justice. And that's hard. People traditionally would look at how many wins they have, as if that would define who a good prosecutor was, or who was the toughest. And yet, that's not been helpful, and we heard from the prior panel that hasn't led to a safer or fairer system. So what we probably need to look at are the individual decisions prosecutors have to make. And when what you're trying to accomplish. So the charging decision. And we heard much from the prior panel on that. And what you're learning in law school, who learned the 4 purposes of punishment? Raise your hand, I won't call on you, but let's see it. Yeah, actually 3 of them were paying attention, Professor. We have various roles. There's retribution. People quote paying for the crime, but that's not easy to calculate because these are people. There's deterrence, and yet that has fabulously failed in our state and others. There's rehabilitation, but that requires an investment in services to have that happen, and for the worst, there is incapacitation. Prosecutors need to consider all of those issues, plus what available alternatives there are. So just deciding I'm not going to charge doesn't serve much of a purpose unless we can have some alternatives in the community and outside of the criminal justice system to do that. Discovery. There was often a time when prosecutors thought, well, that's the defense lawyer's job to get the evidence that helps them. And it has taken a long time since the Brady decision in the 60s for prosecutors to realize it's part of their job to actually help the defense and not to play it too close to the line. In my line of work, every single case we've had of a wrongful conviction, and we've had 17 exonerations or people being freed in a fairly short period of time, which is no great credit to us, but pretty scary about how many people have been wrongfully convicted. And every single one of them, a prosecutor didn't pause to say, this might help the other side. Just kept thinking, well, it might, but I can think of arguments against it. But prosecutors do have a duty to let the other side decide how it will help. Plea bargaining. You know, plea bargaining, in my opinion, looks far too much like the shook, if you know what I mean, sort of the marketplace, you know, when you travel, and people sort of saying, I'll take this, I'll take that, and using numbers and code sections, and very little focus on people. Why is that? That's not because all the time prosecutors don't care, but we have a very large volume going through the system, and prosecutors have not necessarily been trained or given the alternatives to think about in plea bargaining. Sentencing, same thing, plus we have the complication of judges. And nobody really focused on that in the first panel, but you can have a lot of reform-minded prosecutors, and if you have judges who come from a different generation and are running for office and know that they make a mistake, that's the first thing people are going to point at, it makes the system really hard. And then post-conviction. We were the last state to put in Rule 3.8, which says that if a prosecutor after a case is completed finds that there are reasons to believe that it was not a fair and accurate conviction, they have a duty to address that. And I always wondered why. We're seen as so progressive. What was the resistance? So to finish up my answer here is that for prosecutors, you are on the defense side too, because you're on the side of finding the right result. And it's a result of, you know, thinking about how we hire, how we train, the culture. I'll be harping on that a lot. That is put in the office as to what the role is, and oversight. Because prosecutors use an enormous amount of discretion. And with that discretion comes an enormous amount of responsibility and transparency, and we are the ones who should be keeping an eye on it. Did that answer the question? Do I get a full grade on that?
It was.
Thank you very much, District Attorney Jenecke.
I also want to thank everybody for allowing me to be here. It's incredible to be back at my law school and to think about how I got to where I am today. It's a good place to start because I'm going to agree with Professor Levenson. I actually don't agree with the premise of this question, and I'll tell you why. Our only job as prosecutors is to be a minister of justice. Bar none. That's it. It's not about winning. It's not about losing. It is only about the things that serve, the state that we exist in, and us as human beings and how we seek to interact with each other. What justice looks like at different parts of the criminal case filing process is incredible. When you start with, and I'll go even further, and start with the investigation. Our obligation as prosecutors to see justice done starts at the investigative phase. I have the very, perhaps out of this group, unique opportunity to have 7 attorneys in my office, including myself, to still prosecute cases myself. I have 3 trials set in the next 6 months, and to be at my investigations bureau weekly, staffing cases with them to make sure that what they're doing is justice. And so when I look at how the dual role may interact with each other, I think about my own experience. I was a misdemeanor deputy, I was going to trial on a DUI, and I got to court and I found out something about a piece of my evidence and the court excluded it. I'm horrified, like mortified, afraid I'm gonna lose my job, so I run back to the office and I tell my supervisor, listen, I can't prove this case anymore. That is the evidence that I needed, it was the evidence of driving, I don't have enough circumstantial evidence to prove driving, I need to go back and dismiss this case. My supervisor told me I was not going to do that. And it put me in that very difficult position of having to evaluate the interview question. Anybody here who's ever interviewed with the DA's office, the question is, if you think you can't prove a case beyond a reasonable doubt, if you think somebody's innocent and your supervisor tells you to go on it, what are you doing? And the answer every single DA's office wants to hear is, you can fire me first. So I go to the bathroom and I cry. And I walk back into my supervisor's office and I tell him, I am not going to continue trying this case. You can fire me first, because I don't have it. Well, here I am in the same office, so they didn't fire me, which is great. Super good, super good, super good. Feels great now, felt terrible then. But we as leaders of our offices have an obligation to our staff, to our community, and to the defendants that we serve, the victims that we serve, to make sure that justice is the foremost thing in people's minds. Another example, I had an attorney dismiss a felony case without talking to me first, 2 weeks ago. I'm not sick and she calls me, she goes, I need to talk to you about this. She's nervous. And I go, okay, what was your process? So she walks me through it. It was a mental health case. The individual had served a ton of time. We weren't going to get anything out of the conviction. Could she go forward and prove it? Absolutely. Absolutely. She'd already confirmed it for trial. But she told me, she said, Cassandra, it didn't feel right. It didn't feel like justice. So I dismissed it. And I asked her, I go, are you going to go home tonight, look yourself in the mirror, and know that you did right today? And she said, absolutely. I go, would you have felt differently if you'd gone on it? Yes, I would have. Fantastic, you did justice, and that's exactly what we need to be pushing for our prosecutors. That's the goal of what we do. It's to make sure that being a zealous advocate for your case, being good at your job, being good at trial, doesn't supplant justice. And that's the goal. And that's why I don't like the question. I don't like the question because that is not a methodology or a modality that we should be moving forward with. And I will say that you've heard from some juggernauts in our field. I'm going to tell you, I've got a little bit of inferiority complex like running through my body right now. But some of those folks who have spoken to you today, and Jeff will speak next, and your professors, Amy Flynn, Richard Leo, those are the folks putting forward the best prosecutors that we have. That's the future. You all are the future. And so, this is my only plug I'll do today. Please think about being a prosecutor. You're here today and what you think matters, and that's going to matter even more moving forward for our profession.
District Attorney Rosen, we will only have 4 questions, I promise.
So I think that I agree with very much what Professor Levenson and my new colleague from Tuolumne County said, and I would just add a few things. I was a young prosecutor in the Santa Clara County DA's office, and it's always been a very, very fine office. I've certainly brought changes to it, but I think it had a very strong foundation. My supervisor, I was on the drug trafficking team. Not that I was a drug trafficker, but that I was prosecuting drug trafficking. And my supervisor said, oh, these narcotics agents, they need a search warrant to, search this house for methamphetamine, and, they say there's 5 pounds of methamphetamine in the house, and so I met with the agents, and they only had one person, they had one informant who said there's 5 pounds of methamphetamine in this house. And I went back to my supervisor, and I said, I thought our policy was, we're not gonna write a search warrant if all we have is the word of just one informant and no other corroboration, like another witness or, activity near the house that would be consistent with drug trafficking. All we have is this one informant. And I've been in the office for maybe 2 or 3 years, and my supervisor said, no, you really gotta write this warrant. You really should write this warrant. And I did. And I didn't feel good about writing it, but I did. The result wasn't so surprising to me. There wasn't 5 pounds of methamphetamine. There was like 5 ounces or something, which didn't shock me. But I felt bad about what I had done. And I was 3 years there. It's a civil service office, but you need to get promoted. I wasn't topped out in terms of my promotion or anything. And I felt bad about that. And I thought that's not how I was raised. It's not how I think of myself. And if a situation like this arises again, I'm going to handle it differently. And yeah, sure enough, 4 or 5 years later, similar situation on a drug case. It was a murder case, and supervisor said, this one prosecutor has the case, and he doesn't think there's enough evidence for us to prosecute this case, but I'd like you to take a second look at it, sort of second opinion. And I looked at the case, and I don't, when I say looked at it, this was a course of weeks and re-interviewing, and I said, I think this person probably committed the murder, but I don't think I can prove this beyond a reasonable doubt, and so I'm going to decline. And this supervisor, different supervisor, was kind of, hey, I really want you to prosecute this case, just, do the preliminary hearing, and we'll see, and the guy will plead to something. And, I thought a lot about what happened a few years before. And I didn't, we teach our prosecutors in our office, we know that you're going to make mistakes. You're going to make mistakes. Don't make the same mistake over and over again. Like, just make different mistakes. Go out there and make new mistakes. And so I declined, and felt good about that. And whatever, a third prosecutor got the case in the office, and that prosecutor actually took it to preliminary hearing and then dismissed the case after the judge admonished us. So I think that culture makes a difference, and I think that for you, particularly for young law students, when you're going into a new organization, whether it's public defender's office, DA's office, or whatever it is, you're sort of trying to make your way, and you're trying to figure out what are the values of this organization and how do I fit in with that. And you can have policies and procedures and so forth, but it's really, that's one thing about how you create a culture, but then it's actually what's done. So I just wanted to highlight that piece that Professor Levenson mentioned, that in any organization there's always a lot of effort to change laws, which are important, effort to get prosecutors' offices to have certain policies about how we're going to handle this case or that case, and I know we'll talk more about that. And all of those things are important, but but they're not sufficient. And what you have to have are people with good values that are going to try their best, recognize they're going to make mistakes, and have a little humility about it. So, you know, in the same way that we believe in giving those who have committed crimes second chances, we also want to give those of us that work in DA's offices or law enforcement opportunities to learn and grow as well. So,
Thank you for 3 excellent answers. I'm going to ask the law review staff that's keeping the time to show when there's 20 minutes left, so we leave at least 20 minutes for questions from the audience. The next question goes to District Attorney Rosen first. Do prosecutors have a duty to avoid wrongful convictions, and what specifically should prosecutors do to prevent, minimize the wrongful conviction of the innocent? And tell us what you think about the conviction integrity or post-conviction review. We've talked a little bit about that already as a model for prosecutorial investigation of and reform of the problem of wrongful convictions, and or if there's other models that you've thought about or that are emerging for prosecutors to be involved in rectifying the problem of wrongful convictions both at the individual level as well as systemically within your jurisdiction.
thank you for that very compound question. And I think that this question really draws on what we were just talking about in terms of the role of the prosecutor. And so I've always felt that our job is to vigorously pursue justice in a way that's fair and treats everyone equally and with respect. Now, sometimes vigorously pursuing justice means that we're building a case and we're convicting someone of a very serious crime and holding them accountable, helping the victim heal, and protecting our community. But I wanted to make sure that the same vigorousness that we employed in our office towards convicting individuals, we would employ that same level of vigorousness for looking into old cases and exonerating individuals who either were factually innocent or who had trials that were not fair, and we could no longer stand behind those convictions. And so, you know, I'm going to brag a little bit. We had the first conviction integrity unit in the country, and it was started by another prosecutor here who you'll probably mistake me for, whose name is David Angel, who works in my office, looks a lot like me. And the idea here was, this is a human system, the criminal justice system, so there's no way that it's perfect. We know it's not perfect. We know that there have been mistakes and injustices, and so we started this unit. We have a prosecutor assigned to it, an investigator to do reinvestigations, and in my county, the DA's office, I run the crime lab. So a lot of this reinvestigation involves looking at evidence that was at a crime scene 10, 15, 20 years ago, and applying a lot of new forensic DNA technology to learn more about what happened. And in the same way that you could use this kind of DNA technology to solve old cases, old murder cases, old rape cases that went unsolved, you can also use this technology along with old-fashioned police work and re-interviewing witnesses to figure out whether you convicted the right person and whether that was fair and whether you can stand behind that conviction. And that's why we call it a conviction integrity unit. We want our convictions to have integrity, to have strength. And so we've moved to set aside probably 12 or 15 convictions at this point since I've been DA. Some of those situations were, we know this person didn't commit the crime. Many others were, given things that happened, we no longer have confidence that this conviction is strong, and so we're going to exonerate the person. So what does that require? Number one, it requires humility, and to recognize that mistakes happen. Sometimes they're intentional, and sometimes they're negligent, but mistakes happen. And every one of the cases where someone was convicted, there was police officers and prosecutors and judges and juries that all thought this person was guilty and they got it wrong. So one is approaching this task with some humility. Second, in having this unit. We don't have all the answers in the DA's office. You know, we've got a lot of smart people in our office, and as Steve Wagstaff told you, they're all rich and, you know, make a huge amount of money. But we don't have all the good ideas, and so we very much listen to defense attorneys. We work very closely with the Northern California Innocence Project for many, many years. I think Linda Starr is here, and we work with Linda and her staff, and they've helped us, and we have helped them to uncover a number of wrongful convictions. We listen to academics and defense attorneys, and we try to educate ourselves. Third point, it's not enough to have a conviction integrity unit that says, okay, this person was wrongfully convicted, now get them out of prison, or they've already served their sentence, expunge their record, apologize to them. Then what we do, and this was really David Angel's insight, is that's just reactive, but we need to be proactive. So you have a wrongful conviction, why? What were the factors that led to that? And let's then look at our own policies and procedures and practices, both in the DA's office and in law enforcement, to try to change those practices to make it less likely there's a wrongful conviction. When an airplane crashes, God forbid, the FAA doesn't say it's perfect, airplanes don't crash. Okay? They crash, it's not often, but when it happens, they do an investigation. Why did this happen? And how can we build the plane differently? How can we train the pilot differently so it doesn't happen again? And so, very pleased to be on a panel with Professor Richard Leo, who's written a lot about false confession, and we've read his articles, and in part because of that, we then said, okay, we need to videotape all of the statements that officers are taking from suspects as well as witnesses, because we don't want false confessions. We see what happens with eyewitness identification, so we have a different protocol in our county that I can talk about later to try to minimize that. I mentioned an informant in my first example. Jailhouse informants, you know, we almost never use them anymore because we're so concerned about the lack of credibility that comes from them. So those are some of the ways in which we have our conviction integrity unit. It's integral to our office, so different prosecutors and investigators and criminalists work through it because we're trying to create a culture where, yeah, the homicide team is a really important team to be on, and to be on the conviction integrity team, that's a really important team to be on also. All of these things are important and go to our role as ministers of justice.
Professor Levenson?
So, I agree. So let me give you a little bit of background here. How would it feel if you were a prosecutor and you think you have convicted an innocent person? And you're learning that after they have been in custody from age 19 to 53. What have they lost in their life? And that's happening across the country. We don't have exact statistics, but about 5 to 10% of the people convicted of the most serious crimes, murders and sexual offenses, are actually innocent. And if you do the numbers, it could be up to 200,000 people. And those are lives that you can't get back. So on the basic question of do we have a duty to avoid wrongful conviction, that's an easy one, right? Yes, we have that duty. And don't forget that if the wrong person is in prison, that means that the real perpetrator, of course, is out and may continue to commit the crime. Now, I was on the ground floor in Los Angeles when it started to try to do a little bit of what was already being done by District Attorney Rosen, and thank you to David Angel, in taking a serious look at what's happening with wrongful convictions and how it's part of the prosecutor's responsibility to deal with it. And I'm here to tell you that there was an enormous amount of resistance. It just wasn't seen as part of the prosecutor's job. That their hearts weren't in it, and you can create a unit, and you can even put a couple people in it, but that doesn't get the job done, especially if they're seen as, quote, the bleeding hearts, not the real DAs, the persons who are not going to be promoted otherwise, and if they're not given the resources. You see, to do post-conviction work, you need investigators, and we can't use the same investigators who were involved in putting people in prison because their hearts and training isn't in it either. And it also became very adversarial when first created, not collaborative. So you go to at our place, it wasn't even called the CIU, it was called the CRU, Conviction Review Unit. And the first thought by them was, oh yeah, maybe there's a problem, but we have an answer to it. Or it was harmless error. Or that's really ineffective assistance of counsel, and that's not our problem, right? That's the other part of the system's problem. And even when there was a good case, really, really slow. It takes months, if not years, for people's lives to be remedied. And they often did want, even if we could show it was a wrongful conviction, all right, then who really did it? So somehow it became the defense responsibility to show up. None of that actually works so well. So listening to DA Rosen is a really good thing to do, because you have to put in a unit where this is held out as valuable, important to an office, and maybe there's some other things we should think about, in addition to having the DA's office be all in. There are different models that we can think about for reviewing for wrongful convictions. You can have maybe CRU outside the office. Maybe you can have commissions that have people from both sides. I've suggested, what about just some civilian oversight? Now that makes DAs very nervous.
Yes.
To have civilian oversight. But believe me, it's very valuable as well. What about audits? That makes them very nervous. And I would say some of the reason it makes them very nervous is that, you know, when they do have to go out on the campaign trail, they're worried about what might be said. But it's important because of the consequences. And it requires investment. It requires you folks in law school to be open to what it means that this is an integral part of the prosecution. It requires respect for people like the Northern California and other Innocence Project and saying, oh, they're so different from us. Actually, they're not. You know, if you want to get it right, then they are your partners, not your opponents. And then finally, I want to say, this system's so messed up because if the DA's office doesn't fix it, we get into the whole habeas litigation. And that's not traditionally been a particularly fair standard, very difficult, and keep in mind that the people in prison, by and large, are representing themselves. They have a pencil, they have paper, they don't have lawyers until we get in there to help them. And that puts added responsibility on the DAs. So I'm painting a picture not to be grim, but to be hopeful that as we all begin to understand how impossible it is to provide justice without focusing on post-conviction work, that will really incentivize and energize people to approach it individually.
District Attorney Jenecke?
It's such an interesting conversation because as Professor Levenson and DA Rosen are talking about their historical framework for these types of units, I am experiencing that in real time right now. So Tuolumne County has never had a conviction review or a conviction integrity unit. It's been something that I've wanted to start ever since I was appointed, but it really kind of pushed to the forefront and came to light when we had a felony murder resentencing case come across our desks. And my investigative team and myself started to develop some very serious concerns about the integrity of that conviction. We're still litigating it, so I won't provide too many details, but I cannot wait to share in the hope that I can get the former law enforcement agency who worked on the case initially back on board, because there is so much resistance. But what I will say is that the concept of the conviction integrity unit or conviction review unit is absolutely necessary to right historical and systemic wrongs. And it prevents future wrongs by being, as DA Rosen said it, rather than just reactive, but being proactive. When Professor Leo sent out the questions, there was a last little sentence that asked, like, who is somebody that you admire who's working in this area as a prosecutor that's trying to make some changes for wrongful convictions? And I wanted to share with all of you Vern Pearson. So he's the elected DA of El Dorado County. And if any of you have been following, they've had a murder case that's been walking through the conviction integrity process. They exonerated a man who'd been in prison for over 15 years. He was convicted primarily off of the false and coerced confession of a co-defendant. And they eventually found the real murderer based on a DNA hit. And Vern did exactly that. He sat back and said to himself, where did we go wrong? And I think you're gonna love this part. From his perspective, it was the interrogative and interview process of the co-offender. It was coercive. It utilized falsehoods. It did all of the things that my cops, because I talk to them about this stuff a lot, still try to justify to me, right? When I tell them, no, we know that those tactics lead to false confessions. We know that that type of pressure is coercive. Even if you don't mean it to be, it still is psychologically. And so Vern has now created internal policies within his office for filings. If a case utilizes coercive techniques in the interrogation or in the interview, that case is reviewed by one person in that office, and it is him. And he will not file that case if that's the only evidence you have. Doesn't matter how good the interrogation was, doesn't matter how good the confession was, it's not happening for you as a law enforcement officer. And he's even gone so far as to get all of his investigative bureau, which is more sizable than mine, bless him, lucky man, all of them certified in scientifically based interview practices. And they are taking their team and they are trying to educate their local law enforcement agencies. They are trying to educate law enforcement agencies across the state because he so firmly believes that that modality is one we have to stop. And I'll tell you right now, ladies and gentlemen, it's still a process that is taught. It is taught to law enforcement officers every day. When they go to investigative school and they come back, they just want to talk to me all about going to batty and learning all about the behavioral analysis techniques at this institute. And so, do we have an obligation to avoid wrongful convictions? Absolutely. Can you do that through conviction integrity units? Absolutely, and I hope to do so in my own county. But we also have to avoid the same mistakes moving forward. And so, Vern, if anybody is interested in looking at that case, I would please do so, because I would say that's like our most recent example of how we can right wrongs.
So thank you for another round of excellent answers. I'll try not to ask any more compound questions. We might be down to 3. So police are the frontline workers in the criminal justice system. They are, by necessity, I think, involved, or the behavior or practices are involved in wrongful convictions, as well as in rightful convictions. And so my question to this panel, starting with District Attorney Jenecke, is what can or should prosecutors do to help police minimize the practices that sometimes lead to wrongful conviction?
So I think I might have already answered most of that question. No, I'm kidding. So Vern, I think
Responsive answers only.
it's a good example, right, of what we can do, what we should do. Because wrongful convictions really do start at the investigative phase. As I mentioned earlier, I have probably a unique opportunity to be in on most of the large investigations in our county. If they're not calling me, we're gonna have a problem, and they know that. And so, when possible, a way for us to avoid wrongful convictions is to have prosecutors on the front lines with our law enforcement officers to keep them honest and to keep them doing the right thing. An example from our county, the former DA, went to the interview of a homicide suspect, and they didn't Mirandize him right out the gate. He had been handcuffed, he'd been transported, he'd already kind of mentioned wanting a lawyer in the car, but not a direct invitation, and so my predecessor pushed for them to give Miranda, and they said no. And so we go through, they don't Mirandize him until it's a really clear invocation, and we get to trial. The court, even after an evidentiary hearing, lets part of the statement in. I think you all probably know where we're going with this, right? It goes up on appeal and it gets overturned. 50 to life sentence, use of a firearm during the commission of first-degree homicide gets overturned. And it comes back down to my office now, because my predecessor has become a judge, and we have to really assess where we're at. that's the impact that wrongful convictions can have on our process. And so that individual ended up not pleading guilty to murder, not pleading guilty to a firearm enhancement, and getting a determinate sentence instead of an indeterminate sentence because of how law enforcement engaged in that investigation. And I went and had a conversation with the sheriff about that case, and they had to change how they did things because we weren't going to keep moving forward in the same way. And so holding the line and letting law enforcement know what is and is not acceptable is our job. Not filing poorly investigated cases, even when you've got the community and your victims and your victims' families knocking on your door and screaming at you. I've got a case like that right now. I get an email from my victim every single day. What's going on? What's happening? I can't file it. I believe her, but I can't file it because the investigation is poor. And that is a terrible position to be in. That doesn't feel good, but that's what justice is. That's what's right. And so that's also part of our job, is to push back and to lay a boundary and to then enforce that boundary.
District Attorney Rosen, I know you've thought about this question deeply.
I think it's a really interesting question because what it's really getting at is how do you persuade other people who don't think exactly like you do? How do you get other people to see something the way you see it or to change their behavior? And so as DAs, we are law enforcement adjacent. Right? We work with the police a lot, but we're not the police. We oversee their work, we prosecute the police when they break the law, and yet we also work day to day on a lot of different kinds of crimes involving police officers, involving the community. So I think it's an interesting question. One, how do you persuade? Secondly, I think it raises the question, should you be doing this as a prosecutor? Because one view of being a prosecutor is the police are going to bring the reports to me, I'm going to review them, decide what to file, what not to file, and I'm not going to worry about the tactics that were used or whether police officers are wearing body-worn cameras or how they do this or how they do that. My focus is more narrow. But I think, kind of really getting back to the very first question that we talked about being a minister of justice, I think in the role as a DA, it is about doing justice in a broad sense. And we know that justice is not just the result, but it's the process that led to that result. And if the process wasn't fair, then it's not justice. So I have a couple examples of ways in which I influence and change what police officers do in Santa Clara County now. And I think the reason these changes could happen is because I sit with the police officers and the police chiefs in my county a lot. And I'm in a lot of meetings with them, and when they have a retreat, I go to that. And I've worked very hard to have a good relationship with them. I think that sometimes, maybe in a place like a law school, there can be a view that you come in and you're going to tell the police that they're wrong and they're racist, and the prosecutors are wrong and they're terrible, and now this is how we're going to do things. Like you're Moses coming down with from Mount Sinai, and you've got it now. How would you react to that? So, number one, I think that educating is a very powerful tool to help persuade, and I think that appealing to police officers' narrative of themselves, of wanting to do the best and most professional and most honest and highest ethical job they can do as police officers, is a way to try to change the way that police officers do things. If you come at police officers or police chiefs with the view that you're wrong and you're racist, or that's the intonation of how you're coming across, or that's how you campaign, good luck, because they're not going to listen to you. But if you approach it from a sense of, I have an idea that maybe this might be an even better way to do your job, even more professional. So why don't you come with me and my staff to the Museum of Tolerance in Los Angeles, where we'll learn about the Holocaust and racial profiling and how we want to avoid those things. And we're coming not because you're bad and you're terrible, but I know that you want to learn and you want to get better. We changed how we do eyewitness identifications in our county. It was a very long process to bring the police chiefs along, to say, we're going to do it double blind, which means that the officer who's showing the lineup to the witness does not know who the suspect is. And we're going to do it sequentially instead of all at once for different scientific reasons. And we're going to videotape the whole thing, so we're going to see everything that was said. That's what we got to. But it started out with, oh, you don't think we're honest? You think we're tipping off the witness? You think we're like, it's a slightly larger photo of the person who's the suspect, or you think we're whispering something to the witness? And so it requires a lot of time and trust to do that. And so I think that it's very important for prosecutors actually to work with police officers and try to improve where we can what they do. But you really have to come to that with a deep sense of humility and listening, because I know you don't want someone else to tell you how to do your job. And so that I think is something to be careful about. And so I always, I try to be very respectful and light in my tone and writings when I'm trying to move the police officers in my direction, and that's worked for me.
Professor Levenson?
So, I agree. I think what we're hearing is what we know. Folks, police have a challenging job. In fact, many of them are doing the very thing that we don't want to be doing out there on the streets, right? And, you hear there are many, many good officers. We all know that to be true. But we also know that police are people and they make mistakes. And some of them are a little more intentional in making those mistakes than others. As the prosecutor, we can know where these mistakes are likely to be made and try to prevent them, whether it be by training or just how we approach our discussions with them, and certainly be on the lookout for these mistakes in the cases. Many have been mentioned, whether the interrogations were appropriate. I've heard prosecutors sort of say, gee, the guy asserted his Miranda rights, so he must have been guilty. Now that was from the prosecutor because that was the culture. We have to get rid of that culture to know that when people are scared, they might invoke their Miranda rights. Forensics. TV has done us no benefit by suggesting that, CSI always gets it right. In fact, CSI gets it wrong because forensics are only as good as how the evidence is handled and some of the assumptions that are made. Eyewitness IDs, the statistics are, I think, 75% of all of the wrongful convictions that are proven by DNA, there was a positive ID. We're terrible at IDs. The way I proved that to myself is, sadly, I was the victim of a crime, and the police brought me a six-pack, and they said, can you identify the person? When I had a gun in my face, I wasn't focusing so much on the person. I was focusing actually on the gun on my husband. I could ID that gun perfectly. But the only thing that would help me with the ID of that person was a police officer sort of pointing at that individual. Because they wanted to try so hard to keep me and others safe. Don't worry, I resisted. There's tremendous pressure on witnesses, especially post-conviction. People will come forward and want to recant. And law enforcement officers want to protect the conviction, not necessarily because it was their conviction, but because they feel like they're ratting out a colleague. And they'll say things like, well, you can recant, but then we can go after you for perjury. That's problematic. I'm just pointing out all the areas where mistakes can be made. And finally, prosecutors, I think, have a responsibility of knowing what so-called gang members for a long time, whether they know or not, will have an unconscious bias. And saying to them, you're a bigot, is not likely to get to it. Asking them about sort of their background and what has led to it. So my reaction is, the less you can create a us versus them, and that we sort of, it's part of their job to let us look at what they're doing and transparency, and we haven't even talked about open file discovery yet. But the more sunlight there is on what police did, I think the less likely there will be sort of wrongful convictions, or at least wrongful convictions that aren't correct.
So we are only going to do 4 questions. I'm going to skip over question 4 on our list. I'm going to ask one more question, and then that should leave some time for audience questions. Prosecutors know that when a wrongful conviction occurs, it touches the lives of many people, not just the eventually wrongfully convicted person, but the victim and the victim's family members and the wrongfully convicted family members, among others. And so I'm wondering if we might talk a little bit about how prosecutors deal with and what they recommend in terms of the collateral consequences, or remedying the collateral consequences of wrongful conviction. I think I'm back to you, Professor Levenson, to start.
I mean, that's the most challenging question, right? We all know the big problem. The big problem is that we've put far too many people into the criminal justice system instead of looking at fixing some of the causes, whether it be mental health issues, poverty issues, living condition, homelessness. It's just been a lot easier just to throw them in prison and forget about the problem. So single wrongful conviction sends us the message that we see you. We see what's happening here, and that we have to be smarter. Now, the tools for a prosecutor, where these issues tend to come up, are in bail decisions. And different offices have tried different things. Sort of the blanket policy. I think blanket policies have had some pushback, because all you need is one situation where you get it wrong, and people say your whole policy's wrong. And that's not necessarily true, your whole policy's wrong. But you have to be really thoughtful and have a mechanism for people to use discretion and to have oversight and to give feedback. I think the move to sort of decriminalize drugs, a move in the right direction, but again, not all drugs are the same, and not all situations in which drugs are available are the same. Collecting information, frankly, I think is important. The public is fairly forgiving if they think you care. But to care, you have to show them we are keeping statistics on what happens here. We have not written in stone for Moses on high what these policies will be. I know a certain district attorney's office that is having a hard time because they came in with these set directives without listening to all the parties. And finally, we haven't talked as much here, but I think working with the community and alternative services. The one thing we've learned is that a case affects more than just prosecutor, defense lawyer, jury. It's when you're trying to put into place all these alternative courts or rehab situations or collateral efforts. And we only train our students to be prosecutors or defense lawyers, but there's a lot of other organizations out there that need people with a legal background to ensure that as these cases affect the broader community, that's addressed as well. So that's some of my thoughts.
District Attorney Jenecke.
So thinking about the impact of a single wrongful conviction as a prosecutor is horrifying. When I think of an individual who has not only lost their freedom, but the family who has lost them for the period of time that they were incarcerated, the opportunities that they didn't get to have, all of the things that go along with someone being gone for years wrongfully. I can tell you, at least in my office, all of my staff would be equally horrified. The person in that case that I mentioned earlier that's going through our conviction integrity unit is still in my office. And he has struggled sleeping since we figured out that there individual who's assisting me in investigating it has had trouble sleeping and has actually gone into the office late at night, which I told her not to do, but she doesn't listen, to work on it. Because we feel so deeply how horrible that happening is. We feel that. And so in face of that potential impact has to be emphasized to our new prosecutors. It has to be integrated into the culture of what we do. And we have to remember that moving forward, if we do have a wrongful conviction, that requires empathy and humility and a proactive effort to avoid the same things happening moving forward. I agree with Professor Levenson that we have to eliminate the us versus them, because if we're thinking about justice and we're thinking about the impact of a wrongful conviction, we have to think about the impact that has had not only on the individual, but on the community, because that eliminates trust in our system, which we as prosecutors have an obligation to try and protect and emphasize to our community, because without trust in our system, how do we move forward? And so, as I'm just thinking about walking through this process in my office, the obligation that we have is to not make the same mistakes again. And if we're able to do that, then we have done our jobs.
District Attorney Rosen, you get the final word.
I want to offer a hopeful note that really ties back to the thread that we keep coming to here is the role of the prosecutor being the minister of justice. And I think that when we say that in DA's offices, we mean that one in a temporal sense, in a sense of time, meaning we're ministers of justice, how the investigation was done. Did we file charges? If we did, what charges did we file? If that case resolved, what did it resolve for? If it went to trial and there was a conviction, was the sentence fair after the trial? And it extends even today, decades later. Well, someone was convicted in 1999 of a 3 strikes offense and got 50 years to life, and then we look at that case today and say, well, it was 2 residential burglaries, and then passing a bad check. Is that what justice would look like today? And the answer is no. And so we're going to recall that sentence and change it. But the concept is your role as a prosecutor doing justice, it starts before you get the case, and it continues even after the case is not in your hands and the person is incarcerated and you're trying to figure out years or decades later whether that sentence was fair. So I think time is very important. The second way in which time is important, and I think this kind of ties in a little bit what the first panel was talking about, is the decisions that we have to make in terms of filing charges and responding to legitimate concerns of crime in our community may compel one kind of approach at the beginning of a case and a different approach years or decades later. In other words, after someone has killed 3 people and raped 4 women, this is not the time. This is not the time to talk about restorative justice and how we want the system to have a lighter touch and rehabilitation. It's not. But 10, 15, 20 years later, if the person who's committed horrible crimes has now rehabilitated themselves and is worthy of being resentenced and released back into the community, now we can talk about those things. And the community is open to that because the person has been held accountable, justice was done, and now we can talk about mercy. But time is an important element. Talking about mercy when you should be talking about accountability leads to problems in DA's offices. And finally, this concept of minister of justice, we haven't talked so much about mass incarceration. And it is part of the role of the prosecutor to say, do we need to have this many people in jail or prison? Is there another way to hold people accountable that doesn't involve that? And there's a number of efforts that I've been involved in to do that, to shrink the footprint of the criminal justice system. And I want to say that California is moving in the right direction. In 2006, our incarceration rate was 488 out of 100,000. Okay, so 488 people out of high, much higher than other Western democracies. I mean, just exponentially higher. Today, 300 per 100,000, so almost a 40% reduction. So it's not perfect, we're not done, but it's moving in the right direction. That is something to be hopeful about. And the last piece I would say about why it's important to try to address mass incarceration is addressing that addresses racial inequalities at the same time. Because it is true that African Americans and Latinos are disproportionately in our jails and prisons. And so when we reduce the jail and prison population, or we tap policies and practices in our offices which, where we don't prosecute just simple drug use or people having a suspended driver's license, when we lighten and shrink the footprint of the criminal justice system, we disproportionately and appropriately benefit African Americans and Latinos. So addressing mass incarceration is also a way of addressing social justice issues, and it's something that is, I think, central to what a prosecutor should do.
So we have, I believe, between 15 and 20 minutes left for questions. I just want to make a couple comments very quickly. First of all, I want to endorse the Professor Moran rule, I'll call it the Professor Moran rule, that all questions end with a question mark. But I also want to ask that if you want to direct your question to a particular panelist, I think that would be a good idea. And I want to ask the panelists, because I think we would get more questions if we did this, that perhaps only one of you answer each of the questions, unless the audience member asking the question explicitly asks for more than one answer. So hopefully with that we should be able to get more questions, a little bit more audience participation. So the microphone, I assume, will be handed around, unless this is the microphone. Okay, great. We need alumni donations, by the way.
This is the microphone, so if you have a question, raise your hand and then I'll ask you to come to the side.
My name is Adrian, and I just have a question. I guess I'll direct it for Cassandra. I wanted to ask if, just from listening from your experiences especially too, if the DA offices work with like any third-party organizations, maybe legal organizations that give, or like maybe from the community that give guidance and experience when trying to work through like the issue of wrongful convictions and stuff, or is it all enclosed within state and federal agencies? And I ask this because it seems like there's a lot of backlash maybe in establishing wrongful conviction units within your own departments and offices.
Thank you so much for that question. I think it depends on the community in which you're establishing it. So Tuolumne County is 56,000 people. We're very small. We don't have any legal aid organizations. Our public defender's office, while small, is incredibly mighty. And so for us in particular, I think for rural counties, we oftentimes have to go it alone because the organizations that Professor Levenson talked about aren't necessarily kind of readily available to our organizations. And so that's why I think from our perspective, we look at a lot of other counties that have done great things. Like I look at things that Steve has done in his office, that Jeff has done in his office, and we try to model those, and we reach out to those folks who have done the right thing and done it in the right way and have kind of already learned. We get to learn from their opportunities for improvement, right, not mistakes. And so that's kind of what we end up doing, but my understanding is that the larger conviction integrity or conviction review units do oftentimes have a multidisciplinary team model that I think really does benefit their teams.
Thank you.
Thank you all for such an informative panel. My question is for the Chief I think I've read a little bit of criticism in recent years about the fact that attention in this arena is often on the long sentences, the rapes and the murders and people who are still in prison, and not necessarily too much attention on the low-level crimes that may have been wrongful, and that can still have an impact on people's lives even if they're not in custody. And so I wonder if you can speak a little as to what your office does, if anything, on those low-level offenses, or if that's maybe something that's a goal for the future.
You want to start?
Sure. Thank you for the question. You're correct that the conviction integrity unit in our office, that the cases that we tend to focus on, the cases that are brought to our attention to focus on as well, tend to be rape, sexual assault, murder cases, attempted murder cases. In terms of it, but we certainly are open to addressing wrongful conviction in any case. We haven't had as many cases like that come to our attention. But I do want to just add a little piece here, which I know it's not exactly what you're addressing, what you're stating, but one of the things that I think is really important is after somebody has been convicted of a crime, for the vast majority of crimes that people commit, if they complete probation, which generally means if there's a victim, make restitution to the victim, don't commit any new crimes for 3 years or 2 years, they're eligible to have their conviction expunged. And expunging a conviction has a very powerful and positive impact on a person's life. It makes them eligible. Have gentlemen get hired in a government office. You can get financial assistance for school and for housing. And the problem is that it's not done automatically. And so one of the things that I'm just super proud of that we were able to do in our office is, we are the Silicon Valley DA's office, so we wrote software and go through and expunge thousands of convictions a year. And the trick with writing the software is it's not just our system that has to expunge it in Santa Clara County. You've got to get the state DOJ to expunge it. Okay? That's where we needed high-level software engineers. So it's not like we hacked into their system. I mean, it's not what we did. But to make it so that when the judge says this is expunged, and we would, we do hundreds and hundreds at a time, that it actually was, and then to the federal databases and so forth. So that is a way, and again, it sort of ties back to what's our responsibility as prosecutors is to do justice, over the long period here, and also to do it in a way that is positively affecting people in the community, because our interest is not that there should be a crime that we then prosecute. Our interest is that there's not a crime in the first place, and we recognize that the more barriers we put to someone re-entering society, we're closing off the legal avenues for them to support themselves and their families. So we think that expungement is really kind of this low-hanging fruit that could significantly benefit our community, and we're starting it we're doing it in our county, and we're hoping to be able to spread it.
Thank you so much for your question. I'm just going to be so honest with you. Sometimes it's a triaging question, and sometimes it really does boil down to whether or not we are adequately staffed to sometimes just do the day-to-day. Steve talked about it earlier, but recruitment's been hard, and so it is the bigger cases. It is the cases with lengthier sentences that get the most focus in those. Should it be? No. Because everybody who has been convicted of a crime, and if that conviction was wrongful, they deserve the same time and attention from us. But I mean, folks like to call us the government all the time, and we are, but we are also limited in terms of just resources. And so right now I've got 5 people working on a conviction integrity case, but that's also the felony deputy who's handling it with me. She has a full caseload. I carry a caseload. My investigators are investigating other things. And so the unfortunate reality is that no, I think, you know, in smaller offices, they are not gonna get the same amount of attention, and while unfortunate, that is a reality that we suffer from.
Thank you so much.
Thank you very much for all of that. Actually, that kind of touches on where I was going to go with the question. And it has to do with, you know, they joked about it in the first one that recruiting is hard because the pay isn't as good in some areas, and then in Santa Clara it's a little easier because they pay the best. But what is the role of the district attorney specifically in advocating for changes to funding, i.e. pay of its prosecutors, i.e. the pay for all the new people, for all these different divisions? What is the role of the district attorney himself in advocating for that kind of change?
Okay, so it's a great job being a prosecutor. It really is. You know, I worked in private practice for several years, you know, at law firms in LA and DC, and I was doing different kinds of litigation, and I hated it. I wasn't good at it. It didn't speak to me. I felt like I wasn't making a positive difference in any way. And so number one, whatever the pay, yes, you can make more at I walked in with one of a student, yes, you can make more at Melanie Myers than you're going to make in the DA's office. But you're going to be able to feed, you're going to be able to feed yourself. And it's a wonderful opportunity to do good. I know there's tremendous work that defense attorneys do and law professors do and advocacy groups do. But I just want to tell you, when you're in the DA's office, you're the quarterback. You're calling the plays. You're at the center of it. And you can do tremendous amounts of good and reform, not just on the individual cases, but at a more systemic level. So I think it's a wonderful job. And in terms of recruiting people, you know, there was some discussion about, well, you know, we want to just have people from we want people from our community to be DAs, and that's helpful, but, you know, the companies and the organizations and the universities that are the most excellent, they want the best people from anywhere. So USF doesn't just say, well, we're only going to hire law professors from San Francisco, or only law students from San Francisco. They want the best and the brightest from everywhere. And Google and Apple and all these companies, they don't say, oh, we're just going to hire people that live in, you know, Cupertino or Mountain View. And so that's how I view our DA's office. I want for my county, for my residents that I serve, the very best, the smartest, the nicest, the people with the highest character to come to my DA's office and help my community. And so we recruit broadly, and from universities all over the country and universities, you know, within our own county as well. And really the message that we bring in terms of bringing diversity to our office is this is a great place to work. We're going to give you something that you can't get anywhere else. And I have business cards.
And you'll still make more than a law professor.
So the funding piece of what we do is so complicated. And the one thing that I think we as elected officials do is we try to convince other elected officials, our board of supervisors or whatever local governing body that you have, to adequately fund your office to do the job that is necessary. That include, I mean, I had the unfortunate opportunity to be the attorney unit's labor bargainer prior to becoming the DA. And so for a very, very long time, the Tuolumne County District Attorney's Office was one of the lowest paid in the state. It wasn't comparable pay, and that pay was the same pay that our public defender's office got. And they were similarly down at the bottom, right? And so we as leaders within our office have an obligation to make sure that our employees are paid a wage that is commensurate with their experience, commensurate with the amount of responsibility that they carry, and to ensure that our offices are adequately staffed for the workload. I took over my office, I think the average for my attorneys was like 500 cases. And the numbers at the public defender's office weren't much better. And so, actually the public defender and I have now gotten together and like walk. And we're both asking for this year an additional attorney position because neither of our offices have seen growth at the attorney position since 2002. As you can imagine, crime has increased just a little. And so, since then. And so, that's the obligation that we have. I took Professor Leo's class the first year, and I thought I wanted to be in family law. I went and worked for a family law judge and quickly disavowed myself of that terrible belief. Sorry for anybody who works family law here, it's awful. It's terrible. But he told me to go to a small county. Go to a small county, get experience, and then leave and go to a Bay Area county, right? Take the time, put your time in, and then get back. But having an experience of going to a small county, I will never go back. I will never go back. I mean, to be fair, Jeff didn't hire me, which really hurt my feelings. Really did. Still to this day, mildly bitter. We won't mention it again. But you end up where you need to be, and as long as your leaders are doing the right things to make sure that you're adequately compensated for what it is that you do, you are in the right place for you. So yes, you could go work at his office. I think his topped out floor makes maybe double what I make, but it's fine. It's fine, because I'm in the right place. So make sure that you're working for the right leader.
I think we just have 1 minute, so if we could have a quick question and a quick answer, that would be great.
Hi. Full disclosure, I'm a private investigator working for criminal defense attorneys. SB 731 will go into effect in July, which will eliminate any access to criminal records 4 years after all legal requirements are met. And it's not clear from the writing of the bill that criminal defense attorneys will have access to vet their own witnesses. So I'd like to hear what you have to say about that.
I'll look into it.
Well, thank God he said it first. Ditto. Right now, I think for us, we don't know the impact. I don't think and rarely do anybody who passed the bills know what the impact is going to have on our offices. Those lovely unfunded mandates.
Professor Levenson?
SB 731.
SB 731.
Okay.
Serious sex crimes and serious felonies are exempted, but that certainly doesn't cover everything.
Okay, let me take a look at it.
Please give a warm round of applause to the wonderful panel that we have. I think I'm supposed to announce there's lunch.